all our listeners who want the full legal analysis and deep dive on the CAS case ruling between PROFAA and FIFA, we now present the full interview with Guido Germer from episode 4. Thank you.
First of all, it's important to point out that the points of arbitration were actually agreed upon between PROFAA and FIFA. So there was a lot of consensus between the parties as to the rules of the arbitration that were involved in the decision making. As to the decision itself, I wasn't surprised by the decision. This is, of course, a personal view, but I did not see CAS issuing a ruling against the rules, because it would have been a precedent placing CAS as sort of an ad hoc supranational constitutional tribunal, and it would have undermined a little bit CAS's position as maximum arbitral tribunal of sport and its legitimacy with sport federations in general, because those sort of decisions would be reserved for a constitutional tribunal in ordinary courts and not for an arbitral tribunal such as CAS. That's my personal view on the decision itself. That, of course, notwithstanding the fact that mainly the award is very well founded. It's very well constructed from a legal point of view. And going into the key submissions of the parties, the main claims of PROFAA go against the service cap fee. Of course, is included in Article 15 of the FIFA Football Agent Regulations. Certain rules regarding the fees included in Article 14, such as the mandatory trimestral installments for payments of agent fees, that the agents receive the fees subject to actually perceived remuneration of the players, which goes in line with the provisions that the agent is not entitled to receive the fee if the player transfers to another club or terminates the contract without just cause. There were claims also against the prohibitions of dual representation are included in Article 12 of the agent regulations. There was a claim against the prohibition of agent services being provided by non-licensed individuals, against the disclosure and publication rules of Article 19 of the FAR. And there was also a claim regarding an eligibility requirement in Article 5, but we're not going to go into that because for some reason CAS didn't address that particular issue in the award. Just a small disclaimer for the audience. There were several aspects of Swiss law and also minor aspects of French and Italian law and the MLS collective players bargaining agreement that were brought up by the parties and addressed by CAS. But the main reasoning of CAS addressed the relationship between the agent regulations and European Union competition law. So we're just going to focus mainly on that. But of course, if any members of the audience want to review the award more thoroughly, they're more than welcome to go directly to the award. It has a lot of interesting details that we're just not going to be able to cover in the present interview. So going specifically into the service cap fee, PROFAA states that, also for the audience, PROFAA is the Professional Football Agents Association, which is the party that brought up this claim in CAS. And what PROFAA states regarding the service cap fee is that FIFA has a dominant position in the global market for organization and marketing of football competitions, and that it has abused its dominant position in the adoption of ceilings on agent fees and restrictions on freedom of representation, thus breaching European legislation on competition. PROFAA states that the service cap fees impose unfair conditions on small and medium-sized agents by creating factual conditions that deprives them from earning reasonable living and even covering costs. They impose unfair and discriminatory differentiation between agents representing engaging entities and those representing the releasing entities. And the service cap fees equate to horizontal price fixing, which is prohibited by European competition laws, and they prevent agents from substantially competing on price. To these submissions, FIFA responded that all the restrictions applied by the agent regulations fall outside the scope of European Union competition law because they pursue legitimate objectives, such as the functioning of a transfer system and the integrity of football in general. And hence, all restrictions are inherent and proportionate to the pursuit of those objectives. And in any case, the fee caps still leave room to compete beneath the cap. Hence, the fee caps don't violate price fix prohibitions of the European Union because they are regulatory measures adopted to deal with acute and persistent market failures. Then regarding the prohibition and restrictions on dual and triple representation, this so that the audience has an idea of what it refers to, Article 12 of the FIFA Agent Regulations prohibit for an agent representing a releasing entity, that is the club that is selling the player or that is lending the player out on loan, to represent also the player or the engaging or the purchasing club in a specific transaction. PROFAA claims that this is an unfair disadvantage to agents representing releasing entities or selling clubs who may not also represent the player as opposed to agents representing the engaging entities. To this, FIFA responded that the prohibition looks to align the interests of agents with those of their clients, that dual representation of the player and the engaging entity and dual representation of the player and the releasing entity are not alike because there is a clear and unavoidable conflict of interest between the releasing entity and the player because the former seeks to maximize transfer compensation in detriment of the player's remuneration in his new club. And thus, the engaging entity or the purchasing club or the club that is acquiring the loan and the player have a common interest in negotiating a low transfer fee. Then there were some submissions made on the prohibition of unlicensed individuals providing agent services. This PROFAA says that it's a prohibition that obstructs the access of agents to the market because it doesn't allow them to rely on unlicensed employees to provide the agent services, to which FIFA responded that the prohibition is not an exclusionary abuse because it does not prohibit agents from providing general assistance to players, that is other services, and these can be provided by unlicensed employees. The restriction only applies for the solicitation of football agent services and the actual provision of these. And FIFA understands that this is reasonable because only regulated persons can provide regulated activities. And finally, the party submissions regarding the article on the disclosure and publication of information such as the name of agents, client lists, services rendered to each client, sanctions and transaction details. PROFAA claims that this article breaches European General Data Protection Regulations, fundamental rights to privacy and protection of business secrets, and that there are more proportionate measures available, such as the confidential transmission of information and contracts to a special supervisory authority. To this, FIFA submitted that it believes that the European Convention for Protection of Human Rights, which is the convention that protects the rights to privacy, and the European Charter do not apply directly to FIFA because it is a private entity, and that should they apply, and even if the publication and disclosure of agent activity details could interfere with the agent's privacy rights, such interference is justified because it does not extinguish the rights in question and pursues legitimate objectives. And in any case, FIFA obtains all the information with the consent of the agents and processes all this personal data in accordance to the European General Data Protection Regulations. So with these submissions in hand, how did the CAS reason to find that the FIFA agent regulations are legal and valid and proportionate? What the CAS did was first, it went into the legitimacy of FIFA as an institution and the legitimacy of the FIFA agent regulations as regulations imparted by FIFA. Because CAS started by reasoning that it had to answer one fundamental question regarding sports governance, which is, can FIFA extend its regulatory powers beyond the task of governing the sport of football itself and cover peripheral economic activities, particularly the market of football agent services. And CAS observes that at first sight, FIFA does enjoy a so-called technical and democratic legitimacy to regulate football agent services. Because CAS reasons, this activity cannot be properly defined as being only peripheral to the world of football, because agents represent the interests of clubs and players and directly engage in the organization and functioning of the market of players' services. And this is one of the core aspects of the entire football system. And this, according to CAS, is what entitles FIFA to adopt governing rules in the activity of agents, in the same way that it has adopted governing rules regarding the transfer and status of players. And in this adoption of rules, CAS believes and understands that FIFA enjoys a certain margin of appreciation or discretion in regulating activities that are peripheral or intrinsic to the sport of football. Also, CAS highlighted that FIFA went through a thorough consultation process on the matter with relevant stakeholders, and that the FIFA agent regulations garnered wide legislative support from European authorities, and that in any event, should parallel international and national legal systems choose to depart from the principles set out in the FIFA agent regulations, they can do so by imposing mandatory requirements which prevail over FIFA's system of private law. So after that introduction on FIFA's legitimacy, CAS pointed out, based on European Court of Justice case law, that FIFA is what can be considered as an association of undertakings. And what is an association of undertakings? It's an entity that is involved in economic activity and that assumes the responsibility of representing and safeguarding the collective interests of its members. And as an association of undertakings, CAS understands that FIFA may, in adopting the agent regulations, justifiably pursue public interest objectives recognized by the European Union's legal order. And even if the contested provisions of the FIFA agent regulations may be liable to infringe European Union competition law, so long as these provisions are appropriate and proportionate to achieve the intended objectives, such infringement would be justified by law because of this legitimacy that FIFA has as an association of undertakings. So CAS continues to reason, applying case law of the European Court of Justice, mainly two cases which we're not going to go into, but are the Mecca Medina case and the Wouters case. And these cases provide a framework to examine whether or not the FIFA agent regulations are legal according to European case law. How does one examine this validity of the FIFA agent rules? CAS goes on to answer three main questions regarding each of the points that were addressed in the award. The three main questions are, are the objectives pursued by the FIFA agent regulations legitimate? And if they are legitimate, then are the specific measures of the FIFA Football Agent Regulations appropriate and proportional to achieve the intended legitimate objectives? Those are the questions that the panel will answer in the award regarding each specific submission of the parties. So going into the service cap fees, CAS says that these are not a measure restrictive of competition. It is not a price fix in itself, but it may have a restricting effect on competition by limiting pricing possibilities of agents and forcing them to a focal point competition below the service cap line, facilitating collusion between agents. CAS points out that in a market in which the supplier holds a strong position, there is a higher risk that the maximum resale price will lead to its uniform application by resellers. And there is strong evidence pointing in that factual direction in the agents market. Nonetheless, CAS considers that the service cap fees are not discriminatory because they impose dissimilar conditions to dissimilar transactions. And this is in accordance with European competition law. So the first question, Do service cap fees pursue legitimate objectives? CAS answers, yes, they do. The transfer market is integral to team composition and thus determines performance of teams in national and international competitions. And CAS considers that the service cap fees seek to correct reported and proven market failures and to ensure proper functioning of the transfer system, and that the objective is legitimate, and that several subsidiary goals listed in the award have also been recognized by European Union courts. CAS also considers that the measures in Article 15 and in the FAR in general are appropriate to set objectives, because the service cap fees shift incentives from a business model largely based on transaction fees to a more comprehensive model where the agents can charge their clients for each of the services provided. That is, agent services on one side and other services on the other. And CAS points out that the service cap also protects players by limiting conflicts of interest, unethical conduct, abusive practices, promotion of contractual stability, and that FIFA has effectively demonstrated that the prospect of higher agent fees incentivizes agents to generate more transfers. And the final question regarding the service cap fees, are these service cap fees proportionate to the alleged objectives? And again, CAS answers that yes, they are, because the caps only apply to agent services. They don't apply to other services that agents can also provide to their clients. And CAS reasons that the 3 to 6% cap of lower fees applicable to agents representing individuals or engaging entities reference to annual remuneration of the player per year of contract, which means that those agents may effectively receive more agent fees than those representing the releasing entity in the same transaction, because they receive an up to 10% of the transfer as a one-off compensation. And also at this point, CAS also pointed that FIFA provided evidence that the average service fees of agents were at first sight excessive in relation to the player's income, and that the fee caps are proportionate to, for example, the 3% fee cap in the NFL, the 4% in the NBA, 10% of the player's remuneration in Portugal, 8% in Greece, and so on. Other important points analyzed by the CAS: the prohibition of non-licensed individuals to provide agent services. CAS understands that this is not an abuse of dominant position, because the licensing system set out by the agent regulations would be completely frustrated if unlicensed persons could carry out the licensed activity. This licensing system does not prevent agents from using unlicensed employees to provide other services to their clients, and the prohibition is appropriate to pursue the legitimate objectives, and it is proportionate because there is simply no less restrictive alternative, because only regulated persons can perform regulated activities. Regarding another controversial aspect of these new regulations, which is the prohibition and restriction on dual and triple representation, CAS considers that these are not an abuse of dominant position, as they prohibit multiple representation in a single transaction where the conflict of interest is unavoidable. That is, because the releasing entity or the selling club or the club that is lending the loan seeks to maximize transfer fee, and the player and the player's new club seek to minimize it, so the conflict of interest is unavoidable. These restrictions, CAS understands, that allow for the interests of the agents and their principals to align, and thus the measure is appropriate for the pursuit objectives, and it is proportionate because they take a gradated approach based on what party the agent is representing. And finally, an important aspect of the award that was approached by the CAS is the validity of Article 19 regarding the disclosure and publication of information. And in this point, CAS reasoned that Article 7 of the Charter of Fundamental Rights of the European Union, which is the respect of private and family life, and the European General Data Protection Regulations do apply to the FIFA Agent Regulations. CAS considered that Article 19 is a disposition that is general, incomplete, and vague, but nonetheless, FIFA's data processing under Article 19 is, in first instance, lawful. And CAS considers that the interest of the agents and the fundamental rights and freedom of the agents cannot override the pursuit of the legitimate objectives stated by FIFA in the FAR, because they can reasonably expect at the time and the context of the collection of personal data, and that processing will take place. But CAS does warn that any processing of data, and this is probably the strongest point that CAS made against the FIFA agent regulations. This is why I'm stopping in this particularly. CAS said that any processing of data must be limited to necessary information. So it goes on. It goes into Article 19 and it analyzes the different information that Article 19 requires of agents. And it starts analyzing whether it is necessary or not. And CAS considers that all the information required in Article 19 is necessary, except for the details of all transactions involving football agents, including the service fee amounts paid to football agents. Why? Because in contrast to the other information required in the article, CAS considers that the disclosure to football agents of the details of the services provided to each client does not appear to be necessary and proportionate to ensure compliance with any particular provisions of the agent regulations. And on the contrary, the disclosure of such information would qualify as a restriction of competition under European law, because it would remove strategic uncertainty over important competitive conditions in the market of football agent services, and it would incentivize collusion, which will go against other general objectives of the FAR, such as protecting consumers. This was the main, I believe, was the main objection of the award against the FIFA agent regulations, and I think these were the main points in the award.
And with that, it's time to bring this episode of the Agent's Angle to an end. We hope that you found it interesting, if not useful. Please don't forget to subscribe and follow the Agent's Angle on all good podcast channels. Bye for now.
The purpose of the Agent's Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.